Hello, everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded, and we'll be sharing a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Thank you. A very good afternoon to everyone and the panelists. Welcome to the GAR session on navigating disputes related to latent defects in engineering projects. So, in construction and engineering projects, the nature and type of defects can vary dramatically, as can the point at which they can become apparent. At one end of the scale, minor snagging items can easily be corrected prior to a project being handed over. Whereas at the other extreme, significant defects may occur long after the works have been completed and can necessitate extensive remedial works. Therefore, it seems defective works have become a major cause of disputes and litigation these days. With this in mind, we have designed and organized this session to understand latent defects, their legal and contractual implications, strategies for their early detection, prevention, and we'll also speak about some case studies and best practices for mitigating such disputes. So, let us go through some introductions and then we'll get started without further delay. My name is Shweta Shrivastava. I'm working with Mason in Dubai office. I work on delay and technical matters, mainly in the engineering and construction dispute matters. So, today's session is a moderated panel discussion, and I'll be moderating this session in and out with our speakers on the topic. The speakers for the session are Alexander Burrell, barrister at 39 Essex Chambers. Alexander specializes in commercial, construction, and property disputes, both in UK litigation and international litigation arbitration. Alexander is a registered DIFC court practitioner, recommended as a leading junior tier 2 in the legal 500 EMEA. Alexander is frequently instructed as sole counsel in cases of high value and complexity, including in the English High Court, the DIFC Court of Appeal, and in arbitration. Alexander is also on the Attorney General C panel of Junior Counsel to the Crown representing government departments and HMRC. Welcome, Alexander. Next, we have
Hello.
Alim Khames. Hello, yeah. Next, we have Alim Khames, partner at Charles Russell and Speechless. Alim is head of Qatar office and acts for clients in international and domestic arbitration with focus on construction and commercial disputes. Alim specializes in resolving complex disputes in construction, commercial, infrastructure, and energy sectors and has been ranked by the Legal 500 as the next generation partner. Alim has a fellow of the Chartered Institute of Arbitrators and he is a mediator as well. Alim also sits as an arbitrator and is on the panel of arbitrators for several arbitral institutions, including DIAC and KICA. Welcome, Alim. Next, we have Arigna Ghosh. He's a director at Mason. Arigna is a seasoned construction expert specializing in claims, disputes, delay analysis, mediation, and contract administration. Arigna holds a master's in construction law, a postgraduate degree in construction management, and a bachelor's in civil engineering. Arigna has worked on high profile projects such as Mumbai International Airport, Al Rayyan FIFA Stadium in Qatar, Delhi International Airport, and Neom Village, among several other projects in Middle East, India, and Australia. Arigna is an affiliate member of Chartered Institute of Arbitrators and is currently pursuing MRICS. He brings extensive experience and expertise to his field. Welcome, Arigna.
Hello, Shweta.
And the speaker, yes. And the next speaker we have Richard Bailey. He's a partner at Druces LLP, which is one of the oldest law firm in London. He specializes the construction and engineering group within the firm and has 25 years of experience as a solicitor in construction and engineering disputes. He provides both front end and litigation advice to clients both in the UK and abroad. He is a regular speaker at conferences and teaches at university at Milan and Bucharest. He has worked on projects all over the world, including light rail, stadia, housing, high rise buildings, process plants, and pipelines. Richard is experienced in all kinds of disputes, including latent defect claims, which is the topic of today. Outside of the work, he has also been chair of both UK and European Society of Construction Law and of the Chartered Institute of Arbitrators. So, welcome, Richard. Welcome to all the speakers again, and thank you very much for joining us. Let us start with the session today. Now, it's very important to understand the latent defects. Most of us are working in the construction sector and are aware of the different defects which are being faced during our construction projects. So, a defect is said to be a fault. It's an aspect of work, a design, or a material which is not in accordance with the contractual requirements or which may render the whole of the works unfit for intended purpose. Many disputes concerning defects turn on whether a defect was a patent defect or a latent defect at a given point of time. The distinction is often important to establish liability for defects and in the context of settling disputes. So, with this in mind and in the context of the same, Arigna, we would like to understand how do you explain latent defects and at what point these defects are usually encountered. Over to you.
Thank you, Shweta. And I welcome everyone to this GR Masterclass on latent defect. Uh, Latent defect. Now, if I have to define latent defect refers to the hidden flaws in construction that are not immediately visible or detectable after the project is completed, or until the facilities or the units have been put to use and have been run over a period or let's say seasons. To add, these defects often emerge long after the construction phase, making them challenging to identify early on.
That brings to my next question also. So, is it possible to detect these defects at any point of time early in a project? Like you said, it is a challenging task, but is it possible?
Uh, I'd like to give some examples, practical examples, in order to elaborate what the latent defect is, and then I'll come to the second part of the question. So let's start. The first example which I can think upon is basement waterproofing leakages. So this is, let's say, a very common latent defect which involves water infiltration into the basement and thus affecting the waterproofing works. Now, often this is due to the high porosity in the concrete or due to rising groundwater levels during certain seasons. Now, because this is not happening during the construction phase, why it doesn't happen? Let's say it is because there are dewatering techniques which are being utilized. Therefore, this is not usually detected during the construction phase. If at all there is some problem in the waterproofing. But this becomes evident only at a later date when the project has been completed and has been put to use. I'll just touch one more example and then I'll try to explain that this is basically on the stability issues. Let's say, for example, within the doors and windows which has been installed. So there can be problems which can arise on these fixations of the doors and windows if poor quality sealants or untested materials, let's say, for example, some different kind of joinery materials which has been used. So these issues typically surface at a much later date. Now, coming to your question, why these defects, when are these defects encountered? So latent defects generally are encountered after the building or a particular item has been put for an extended period and often during a season or usage phase compared to the construction period. So under these circumstances, it is actually difficult to identify the responsibility of the latent defect and determine how to resolve these issues. Yes.
Yes, thank you. Now, next topic which we will cover is the defect liability period. So, this is a clause which we often see in the construction contracts, which requires the contractor to return to site to remedy defects, and the time period which is stipulated is usually 1 to 2 years after the project completion. So, If we have noticed in the construction contracts, most of the defect liability period clauses are limited to the patent defects, which are also called the obvious defects. And the contract usually does not cover the latent defects, and they do not even refer to the words of latent defects in the contract as well, and they reach usually stops at the end of the defect liability period. So Richard, in this context we would like to understand what happens when a latent defect is found after a DNP period, as in if a defect becomes apparent after the rectification period, can it still be notified and the contractor can still be asked to return to site and correct it? How do you deal with such claims from a legal perspective?
Well, first of all, good afternoon to everybody. Thank you very much for that question. Defect liability period. Now, obviously, to introduce that topic just a little bit, it's a 1 or 2 years. So that's for anything that might be a patent defect, for an obvious defect, or ought to have been an obvious defect. So we sometimes have arguments in litigation about whether something was actually a patent defect during that defect liability period. And that's where we might get a crossover with latent defects. Now, the question you've asked is, if once they become apparent and they become apparent after that defect liability period, how do we deal with them? Well, contractually, the contractor has an obligation to return to rectify those defects found within the defect liability period. After that period, they don't have an exact obligation to come back and rectify it. If it's just after something, depending upon the relationship, sometimes we can get to the point where the contractor will come back and sort something out. But if it's latent defects within the works or design as well, let's not forget that latent defects can be design related as well, quite often are design related. It will always end up, in my experience, and other members of the panel may comment differently, that you start to write to the parties, and then usually it's going to be considered a form of a claim on their insurance, because they'll have insurance for their damages or a claim against them. And we'll get into the whole process of reviewing that claim and pursuing that against them, because they will start to talk about how, especially if it's materials and workmanship, how such a long period of time has passed, that the plant has been in use, the property's been in use, that there's obviously intervening causes, there's been other damage done, whatever, to the building. So we have to start to look at expert evidence and to engage to try and find the actual cause of those problems. So that's, in a nutshell, how we would deal with them from a legal perspective.
Okay, thank you. So extending the same question, so Ali, maybe you can share your views. Is it possible to extend the defect liability period? And another leg of the question would be, is there anything called latent defect liability period? Have you ever encountered that such a clause in any of the contracts in your experience?
Thank you, Shweta, and good afternoon to all for joining us here today. I think to your first question, Shweta, it is possible to extend the defect notification period, and we usually find that provision in the relevant FIDIC contract. As Richard alluded to, is that generally in smaller projects, you might see a DNP, a shorter period of 6 months. In airports, power plants, big projects like that, you may see something longer. I'm looking here at 11.3 of the FIDIC Red Book. This is the 2017 edition. And what that provides for is that the employer shall be entitled to an extension of the DNP for the works, or a section or a part. Subclause A says, if and to the extent that the work, section, part, or a major item of the plant, as the case may be, cannot be used for the intended purpose by reason of a defect or damage which is attributable to any of the matters under subparagraphs A to D of subclause 11.2. If you then scroll up to 11.2, what you find is that subclauses A to D usually refer to matters for which there would be an attribution of liability to the contractor, something that the contractor has done, in which case that allows for an extension of the DNP. FIDIC Red Book also then provides that a DNP shall not be extended by more than a period of 2 years after the expiry of the DNP stated in the contract data. What I've seen in certain situations is that if parties want to extend it beyond those 2 years, and this does get quite complex and messy, is that they may well try and circumvent it by having a supplementary agreement. A supplementary agreement then contains its own defect notification period and a defects liability to get around the fact that you can't extend past 2 years. So this is effectively a standalone clause in a new agreement. That does have its fair share of legal challenges, but it is something that I have seen done in the past. You asked me finally whether or not it was possible or whether I had seen a separate notification period
Yes.
for latent defects. I have had one instance, I think, where it provided for that, but in that particular case, latent defects weren't an issue. So when it went to arbitration, it was just not in question. The parties were dealing with other things like time and cost, but not necessarily defects, if that makes sense.
Okay, fine. Arigna, I think we were discussing earlier, like you in one of your projects, you have seen a clause on the latent defect liability period. So if you would like to share your insight on that particular project and the clause which you have encountered in one of your earlier projects.
Yes, Shweta. So there are certain contracts wherein this particular latent defect clause has been put. So the contract which I'm talking about was for one of my airport projects. So given the fact that there are a lot of subcontractors and a lot of associated suppliers who are linked to an airport project, therefore, and it's not only national, whereas international contractors are also involved. Therefore, it becomes all the more essential that these particular latent defect clauses are inserted. What it does is it actually binds a particular period. It usually varies from 5 years to 10 years, and even in certain cases, even 15 years of period, depending on the discipline where we are putting this particular clause. And therefore, the responsibility is passed on to the particular party.
Okay. So I mean, I understand it's a rare case scenario where we are able to see a latent defect liability period. So it happens in very rare cases, it seems.
Rare cases, and of course, I like to say that it is usually kept in very high value projects.
Okay. Okay. Understood. So now we have understood what a latent defect is and how does defect liability period operates and what happens when a latent defect is encountered after defect liability period. But the next question, which is very important, is to understand the responsibility for those latent defects. So since many parties are involved in the projects like that and the projects are years old, it is difficult to establish the responsibility for the latent defects over a long period of time. In order to understand how the responsibility is being allocated and how to establish the same, I have a sample case study wherein we will try to understand the situation, the scenario which is there, and how the parties have conducted their works, and who is liable for the latent defects is something we will try to understand using this case study. So the case over here is there are three parties. There is employer, a DNB contractor, and a PMC and feed consultant. Now the DNB contract states that the contractor is responsible for his part and the works which are finally produced must be fit for purpose. Another obligation which is put on the DNB contractor is that he is to carry out the designer works and shall take full responsibility for his design. So that's what the DNB contract says, and this contract is governed by English law. The PMC contract, which is the PMC and the feed consultant, his obligation is to use skill, care, judgment, supervision to ensure that the works are of good quality and meet the performance criteria. That's the first one. The second one is pertaining to providing advice on the commercial operation of the plant to the employer within his expertise and experience. These are the obligation of the two parties. Now the scenario or the facts of the case is like this. The project commenced somewhere in 2015. DNB contractor requested PMC to provide clarification on the feed issues which remained unanswered. The DNB contractor still proceeded with the design. Finally, the performance tests were not successfully completed. Despite of that, the PMC advised the employer to put the plant into commercial operation in 2018. Obviously, since there were certain issues with the design and everything, the plant did not perform as expected and there was reduced output. Finally, the employer did not issue taking over certificate to the DNB contractor. his performance guarantee was not returned. After around 6 years, in 2024, the employer contacted DNB to rectify those latent defects which they have encountered. However, DNB refused because it was beyond the defect liability period. The employer subsequently issued a claim for damages against DNB contractor for breach of contract and latent defects. So this is the case scenario which we have. Now, Alexander, I would like your insight on this. How do you evaluate the case scenario over here, and how do you establish the liability in this case?
Hi there, Shweta. Firstly, thank you for the introduction. Good afternoon. It's a pleasure to be participating in this alongside my fellow panel members. So I appreciate there's a bit of info in this slide. But to establish liability or to sort of think about how you would go about bringing a claim on the basis of this scenario, I'd suggest there's 3 points to think about. Firstly, which party has potential liability and what ground would you bring a claim against each or either of those parties? Secondly, do you have or do you expect to have the necessary evidence to establish that liability? And third, and this is one of the key things to think about in relation to latent defects, is are you within limitation or are there any limitation hurdles in relation to the potential claim? So the first of these is which party and what cause of action. So there's 2 potential parties that the employer can go after. The main contractor, who's a design and build contractor, and the consultant. And there are potential claims in both tort and contract. We've got the contract terms set out on this slide. The contractual claim against the design and build contract would presumably be having regard to the reduced output, that it was not fit for purpose or that the works as constructed were not fit for purpose. You usually find that sort of obligation within a design and build contract. It relates or it attaches to the design obligation. So in a more classic construction contract without that design, you may not see that fit for purpose obligation. The contractual claim against PMC would be a breach of their obligation to use care and skill to meet the performance criteria and or to advise as necessary. This is a substantively different contractual obligation. It's not a requirement of the plant or the project being fit for purpose as such, but it's to exercise what would be their standard of care as a professional. In fact, it largely mirrors what their professional obligation would be in any case. So to exercise the care and skill of an architect or an engineer in this case to the employer. So you'd have to find something that would demonstrate that the standard of care fell below that of an experienced and competent engineer. In relation to what evidence, so what we'd be looking at here is, firstly, this is going to be touched on, I think, or has already been touched on. Evidence can be quite problematic in latent defects claims because there's a lack of documentation, or can be a lack of documentation. But in relation to the claim against the design and build contractor, what we're looking at is evidence that would demonstrate the works are not fit for purpose. So what's the contractual requirement for the output? What is the evidence of the reduced output? And what is the evidence that that is related to the construction of the works as opposed to any intervening matter that happened after the conclusion of them? And similarly, in relation to the claim against the PMC consultant, we're looking at 2 things. The evidence, so I think there's 2 bits. There's a failure to provide information on the FEED and also the advice to put into commercial operations despite the unsuccessful test. Do either or both of those, either separately or together, meet that test? Possibly. But also we need to demonstrate that that was a cause or a later cause of the reduced output to establish the claim and damages. The third point is in relation to limitation. Now, this can be a very, very relevant and sometimes terminal problem for latent defect claims. There can be a need to act fast as soon as they're identified. It can mean that your claims, for example, under contract are restricted. It does vary on jurisdiction. So in this case, we've got an English law governing law clause. And under English law, there is a 6-year limitation on construction on contract claims. Sorry. If the contract was signed as a deed, that would go up to 12 years. And so it's quite common that you see construction contracts for certain works and various guarantees in deed form. So it gives an employer a bit more protection. In relation to a tort or negligence claim, there is a separate period. It's either 6 years from the cause of action, which would be the practical completion, or 3 years from the earliest date on which the prospective claimant had the knowledge for bringing the claim and the right to do so. The knowledge for bringing the claim is itself is concerns knowledge of the fact of the damage and knowledge that that was attributable to the act or omission alleged to constitute the negligence. Assuming in this scenario that the contract's not a deed, it was put into commercial operation in 2018. It's now 2024, so that is 6 years. So for contractual claims, we're at or potentially just post the expiry of that period, meaning that we may be limited out, and at least in relation to a contractual claim. And so we need to identify where exactly we are with that, what month there was practical completion and what month we are about to bring the claim in relation to the contractual part of it. Here it says that the taking over certificate's not been issued. That doesn't necessarily mean that practical completion hasn't been achieved, but that is clearly one of the risks for the employer in commencing litigation, at least on the basis of contract in this scenario. But tort claims would be different. As stated, it would be 3 years from the knowledge of the defect and that it was caused by the alleged negligence. We don't have the information on this, but that would be something that would need to be established before you look into it. Finally, briefly, sorry, I've gone on a bit. Under UAE law, which I know some of our listeners might be interested in, the periods are different. It's for a commercial claim, it's 10 years, and for a delict claim, it's actually similar to English law, 3 years from the awareness of harm and the person responsible. But yeah, so those are important points to think about before you bring a claim.
Thank you so much. That was really informative and given us a lot of insight on the same. Richard, we would also like to have your inputs on the same. How do you think? How do you think, like, if the claims on the latent defect can be pursued both under the contract and tort as well? Is it possible to pursue this claim under tort as well, and under what circumstances in your experiences?
Yeah, well, there's a few points, and give me a go back over a couple of points Alexander's already dealt with, but I just want to capture a few things, especially when we're talking about contract and tort, and slightly to amplify one of the things that Alexander's already said. Just to point out that although strictly in the UK context, we've recently had some changes in liability periods through the Building Safety Act in respect of what are essentially latent defects in cladding and fire risk issues, where we actually, quite unusually for English law, backdated the provision to go back 30 years. So that is picking up latent defect claims, and even things that we didn't know were latent defects in claims at the beginning of the 1990s. And going forward, there's a new 15-year limitation period that's been introduced, particularly for fire safety issues, which would inherently be latent defects if these things are being picked up. So I just want to mention that. The other thing I just want to mention on limitation is that where there is actually a difference depending upon what the claim is. So if it's something of this workmanship as a contractor is either 6 years or 10, 12 years, for limitation from the date of practical completion. But we always have to remember, Lois, that when we're dealing with tortious claims, which are not against a contractor, which are designed so by an architect or an engineer, the date of the arising of the cause of action is actually earlier at the date that the negligent work, when it might have been discovered, was happened. So we do have to be quite careful around those things. I think that going back to the fundamental question, which is pursuing these things for latent defects, depends upon what it is. Is a latent defect, for example, the discovery that where there'd been a specification that you weren't to use certain types of materials in the construction of the wells. And the reason for that being that the use of certain materials is deleterious to the condition of building. Unbeknown to everybody, during the course of works, some deleterious materials are used, and 7, 8, 9 years after work's done, you find out that that's happened, a contract's been signed under a deed, you go back and you make a claim for that. Also, the other part is that where there's been some error in the design, negligent design, so you've got a tortious claim. You actually have a choice then. Do you go under contract or do you go under tort for your tortious claim? And that's one of the points that will always be considered. And you'll look at the terms of the contract, because sometimes there'll be an exclusion of claims that are tortious claims or common law claims from the contract. Sometimes there won't, and you've got a choice of which way you wish to go. A lot of that will then depend upon what the likely losses are and whether you are looking to recover, and there's a limitation on the type of either a tort and law of tort and limits that there are under law of tort, or express contractual exclusion of certain types of liability where there's no exclusion at all. So you may wish to go down a tortious route to try and pursue damages that have otherwise been excluded if you present it as a contractual claim. So really, one of the things that I would always do, and I'm sure everyone else does when they're considering this, is you look at the various options that are available, various different lines that you could possibly go down. You look at the limitation periods. I mean, we're always very, very nervous. Any lawyer is always incredibly nervous near a limitation period. In fact, we never want to get close to a limitation period. And we want to make sure that any proceedings are issued well in advance of that proceedings. So hopefully, although it was quite a long answer, so I apologize, that's covered off the points.
I have another question on the same. So what kind of losses are usually claimable under such kind of claims? There could be some direct, like economic losses. There could be other kind of losses which are claimable, which are not claimable under latent defects. So if you could, put some light on that as well.
Yeah, again, partially it's going to be looking at the contract, because there may be exclusions of certain types of losses, but also any loss has to be reasonably foreseeable losses. So there are, and it's law students have taught for years for these topics about what's in and what's out. But essentially, you have to look carefully at the foreseeability of those losses. Pure economic loss, coverable. You have to actually pin your losses to arise as a result of that latent defect. And sometimes you may find that you've got a latent defect that you decide it's not economical to pursue the claim, and what's the compensation that should be received instead, because you have to live with that particular claim. But there's a lot of, I'm sure a couple of other people on the panel will have comments on what they think would be the appropriate things to look at for measured loss as well.
No, I think you've covered it well, Richard. Yeah, certainly if you are looking at, well, it's certainly exclusion clauses within the contract are key to look at when there is an exclusion against consequential losses or other similar loss of profit or whatever might flow from defects. But otherwise, the usual, it's certainly in English law, the usual principles of remoteness and what flows from the alleged breach. Of course, this will vary if you're looking at something under different law. I know that under Emirati law there are other sort of sometimes even tighter restrictions on what can be recovered. Of course, I'm not an Emirati lawyer, so not an expert, but from my experience in arbitrations. But yeah, so it can vary.
Yeah, thanks. So now we have understood how the responsibility, is being identified and established in the latent defects. Now moving on to the next topic, which is drafting contracts. So we need to understand the best practices which are there, which needs to be followed in drafting a contract to mitigate the risk related to the latent defects. So as we have already discussed earlier, the construction contracts do not really refer to the latent defects as such. So we need to understand what is required in a contract to safeguard ourselves from some latent defect risks. So this question is open to all the panelists. They can provide their opinion as to what provisions must be kept in mind to deal with the issues of latent defects while drafting a contract?
Well, I'm happy to start off with one point. One of the major risks in a beyond sort of limitation and being able to get evidence in a latent defect claim is insolvency. As I'm sure many on this webinar will be aware, insolvency certainly in the English market for construction is very high at the moment. There are thousands of insolvencies, so it's a risk that needs to be guarded against, and you don't know what the economic conditions are going to be when the latent defect arises in 5 years, 10 years time. So having something in place in the contract to deal with the risk of insolvency is something that I'd highly advise. You can get parent company guarantees or direct subcontractor guarantees between the employer and the subcontractor, so that if the main contractor goes under, you still have a route down to go down. And I think insurance is also something that can be considered. I think Richard might have something to say on that.
I also wanted to add from a UAE perspective is that oftentimes we're asked the question, and I think it's come up today as well in the chat, is the difference between latent defects and decennial liability. There often seems to be some confusion regarding the two. So it's something that we see in contracts as well. To summarize, decennial liability is a statutory obligation from which you're not permitted to contract out of. So put another way, decennial liability under the Civil Code in the UAE applies irrespective of what defect or defect rectification regime you have in your contract. It provides for a 10-year liability in the event of a structural defect. So when we say decennial liability, what we have in mind oftentimes is a structural defect as opposed to a non-structural defect. So a latent defect could be one or the other, but oftentimes they're conflated in terms of, how does this apply vis-a-vis decennial liability? So I think one thing to keep in mind when drafting a contract in the UAE or even in Qatar, where the position is similar, is that decennial liability stands irrespective of what you have in your contract.
Okay, thank you. Does anybody of the panelists wants to add something on that? Maybe we can speak about the insurance policies, maybe something about the warranties which are there in the
If I
contract.
could say something just quickly on drafting contract best practices. I do get to use that horribly English phrase, a bit of bee in my bonnet about contract drafting some days. And insolvency is one of those big issues. The other big issue, I think, is actually when people draft a contract, actually understand the project that they're drafting the contract for. Because too often, and I don't want to sound critical of my own colleagues, and I'm certainly not talking about anyone on this panel, but you do get lawyers who do not know what the job is that they're actually looking at. And it's really important for when drafting a contract to actually have an understanding of what the job is so that you can understand what the major risks are. So if you've got a very high value job or one where it might be a certain type, length, you've got insolvency is obviously quite a key. You may also want to make sure that you have certain protections in place. Those might be, and this goes to your insurance, apart from making sure that there's professional indemnity insurance in place for all those who carry out design obligations, you're going to want to make sure that there's a parent company, or as we like to say, an ultimate holding company which actually has the asset. You might want to get a guarantee off them because you might have concerns about what might happen. If there's a JV, you're going to want multiple parent company guarantees from each of the JV parent companies. You will want to look at performance security, whether that be in the form of performance bonds or, as is coming in particularly pertinent to what we're talking about today, latent defect insurance. Which
Thank
is
you.
increasing in the marketplace, that people are making it an obligation to have some kind of insurance in place that is going to cover for whatever the period of liability might be. That's becoming particularly pressing in the UK, where, of course, now with these changes in limitation periods, we're actually drafting clauses which refer to 12 years and 15 years in them. So there's a lot of it. And actually, one other thing I will mention, and this is only because it came across once my desk, and now I do draft it is of course, even if you're in a contract, the limitation period is 6 years, there is an argument to say that you can still say it's a 12-year liability period by contract. And so you can actually draft in if there are particular issues and it's underhand or you can't organise signature by deed, for whatever reason, expressly stating what the limitation period is going to be. This is sometimes quite useful. So that's a few comments from me.
Yeah, thanks for that. Really helpful. Okay, so
Very
now
quick.
we have understood. Yes, Sarita, please.
Just one point from the claims point of view, whenever these latent defect clauses are being drafted, it's essential that the inspection and the reporting process is also identified and put properly. So this will facilitate at a later date when the claims are being drafted that where the defect has been identified and what are the further processes required post identification of the defect. So this, if the clarity is there in the contract, it facilitates the further dispute resolution process.
And then in that case, how do you also define the detailed specification and the correctness of those? Because they are also, yes.
It again varies on the case-to-case basis, what kind of defect is being identified and whether the particular specification has a provision for such consideration, whether the contractor has followed the specification or not. So there will be a particular root cause analysis kind of thing which will be done, whether the methods have been identified properly, whether the specifications has been followed, is there any deviation which the contractor has adopted. So based on all those study, only the next process comes in. But what I'm trying to say is it's better if we establish a process. So we identify a defect and then what is the next step? So that makes it easier in the later part of the claim.
Understood. Thank you. Now the next is the expert involvement. Like a lot of disputes these days are related to the defects which are being faced in the construction projects, and they either go to the litigation or the arbitration. So the expert opinions, they play a very important role because they are the people who have specialized knowledge and expertise in the area and who are able to decode those technical issues and understand, try to and make those issues easier for the tribunal to understand to make a proper decision. Now, as we understand in the expert world, the evidence and the documentations, they play a crucial role in establishing any case or any claim as such. So Rigna, we would like to understand from you what evidences and documentations are typically required to support such claims, and are they easily available? What are the problems or the challenges an expert faces while handling such cases?
Uh, Okay, I'll answer the question in two parts. First, what kind of documents are required to maintain so that it becomes easier if a claim is to be developed at a later date? Like I said a while back, the first and the foremost, most important document will be a root cause analysis. It is very essential for whichever is the party, whether it's a contractor or the employer, that they should understand that the moment defect is notified or defect is observed at site, the first step is they perform a root cause analysis, why the defect is performed and what has led to that defect coming up. So the person or the team who is doing this kind of root cause analysis will generate a report. Now, making the claim, this report becomes one of the most important documents. Why it becomes an important document is because it will have a clear and detailed record of the defect, which is crucial in formulating a claim at a later date. So this is one of the documents which needs to be maintained. Something else which I can think upon is there has to be something of maintaining a timeline of the documentation. Like, for example, I want to say that whenever the construction activities are happening, so there has to be a record of different types of construction activities. So such documents should be properly maintained. Any maintenance work which has been done in order to rectify that defect, so that should also be recorded properly. Similarly, any effort which has been done to in order to fix that defect, internally. So those kind of documentation records are also essential. Something else which I have to think on is, let's say, there can be cases where the root cause analysis in itself doesn't give you a foolproof case of what has happened. So in those cases, it becomes very essential that the party goes for an technical expert or a third party opinion who is actually aware of that particular matter, what it has happened. And certainly in when the previous root cause analysis is inconclusive. Uh, other records can be the financial records which they are spending in order to for this right from the date of the occurrence of the defect till the claim is being generated. So all the financial records which is happening. So examples of financial records can include they can do a estimate of the damages at the first up, and then let's say it's a particular building which has already been under beneficiary use, but because of the defect, that building is not being used. So the losses because of that. So all these things can be recorded and they can be kept as a particular record. Last but not the least, of course, the project records. So by project records, I mean the correspondences, the NCRs, the snag list, the work inspection report, material inspection report. What else? And of course, one of very important thing is site photographs. So this actually helps in a lot of cases when the claim is being built at a later date. Yes.
Sure. Thank you so much. I think this brings us to the end of the session. However, we have some questions from the audience. So one of the questions which we have is the contractor generally liable for latent defects for the entire design life if there is no fixed time period agreed in the contract, assuming that design is the responsibility of the contractor itself? Ali, maybe you can answer this question.
I only caught part of that because my sound was distorted. So the question was, is that in the contract, if there's no provision for DLP?
Yes. So I'll just repeat the question. The question is contractor generally liable for latent defects for the entire design life if there is no fixed time period agreed in the contract?
I mean, first of all, just as a matter of experience, that would be a very rare situation. I haven't often come across a circumstance like that. I think if that were the case, it would be very unlikely that the contractor would be responsible for the entire design life, even if it was 10 to 15 to 20 years later, simply because of any applicable limitation periods under the relevant law, whether that would be UAE or Qatar or England and Wales. That would be my short answer.
Sure. Alexander and Richard, there is another question which one our audience has raised. So they've asked, do you have a good examples of general contractors' duty to inspect structures constructed by the other parties before performing their own obligations? For example, the interface contractors.
That's a very good question. And I'll guess I have my answer to that is going to be in parts, because what we're essentially talking about, you're talking about for a new contractor coming in and some previous work's been done, is site risk. So what is the obligation of a contractor to check their site risk? Now, most contracts that I get involved in where you have to, there is an interface between what we might call the base build, the original, and this, and a intelligent contractor will make sure there are provisions drafted into the contract which deal with defects in that base build and who's going to correct them and who's going to carry the costs. But if you're acting for the employer, you're going to want to say, right, you have an obligation to inspect the site, check everything, and to confirm for yourself that everything is in good order. So it depends where the contract lies on a spectrum as to what the actual responsibility will be for the contractor, and that depends upon the drafting and how savvy that contractor has been and what their position is for negotiating purposes when they're negotiating with their employer. So that would be my broad answer.
Yeah, thank you. Alexander, do you want to add anything on the same?
No, I don't really have anything to add. I think Richard's answered that. I mean, there are clauses that I've seen examples of times that there have been clauses which deal with inspection of other works and satisfying the new contractor or other party satisfying itself as to the adequacy of those works. But yeah, it's all individual drafting, isn't it? So yeah, I've not got anything further to add to what Richard said.
Okay, thank you. I think these are all the questions we have for today. So that brings us to the end of the session. That was really insightful, and it was very nice to hear the views of the experts in this area. So thank you very much for your time today and joining this session. I think somebody wants to add something. I heard a voice.
No, it's just I think there's one more question in the question and answer.
Okay, maybe we can take that forward. So is it advisable to put a latent defect provision for a ground improvement subcontract, like for the piling system? So Alim, maybe you can answer this question.
Hard to say without knowing more about the sort of the fact scenario, but instinctively I would say, based on the little that we know, I would say yes. Just given the nature of that particular project, I think that would be beneficial.
Okay, thank you. And thank you very much to all the guest speakers for sharing your views and experience in this session. It was very insightful and informative for the participants. Thank you all. Thank you very much for your time today.
Thank you.
Thank you.
Thank you,
Thank you.
Lisa.
Thanks. Yeah, yeah. Bye. Good day.